Appeals Division 1 is now in session.
Thank you all. Please be seated. This is a time set for oral argument in Brent and Catherine Helmke versus Service First Realty, our case number CA CV140078. Each side is allocated 20 minutes for oral argument. Appellant, if you wish to reserve a portion of that time, feel free to do so, but you need to keep track of your own time at the clock on the podium. Out of respect for counsel, I would ask that those in attendance make sure that their cell phones are off so our arguments aren't interrupted. We have read the briefs. We've conferenced the case this morning. We're familiar with the record. We'd encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted in time on YouTube. So I would ask that as you approach the podium and begin your presentation, you identify yourself and the client that you represent. With that, Mr. Thomas, you may begin.
Your Honors, Counsel, Neil Thomas for Service First Realty from Thomas & Markson. Good morning. I'll reserve whatever time I have left for rebuttal. I'm expect it to be a lot because I don't have a lot to say. This appeal before you is really about two propositions, or maybe one proposition and a sub-proposition, and it is, do words mean things, number one, and number two, do the words of this court mean things? I've presented to you in the appendix the very simple instruction that we're fighting over whether the court should have been given, and the very last words said to me by Judge Duncan when she denied the motion for new trial was, I am educable, but I'm not educated, motion denied. Now, what's important about these words go to the heart of agency representation. Everybody knows that an agent talks for someone else all the time. And when you talk for someone else all the time, this court made it clear in the Aranki case that when you pass along information, you're not liable for passing along information unless you have reason to know it's wrong. And I could quibble with you on whether it's had reason to know or actually known, but it isn't of moment in this case. I don't believe that the principle of negligence goes into it because that implies the duty of investigation. And of course, this court in the very same case recognized that real estate agents don't have duties of investigation, and so did both of the experts when testifying at trial. But I want to give a real brief recap of the facts because that's the non sequitur. The first fact which plaintiffs dutifully and diligently unearthed is that Debbie Cox had some involvement with the guy who did the surveys and laid out the land when the never appearing, never defaulted defendant, Katie West, was going to build homes and sell them. And she said, I can do a better job if you get a road to go up there. And that's how the road got, the paved road got put into the road in the condition it was in, which ultimately their own construction contractor conceded was a pretty good road, and was shocked when the department, when trying to go to zoning and said, hey, you're going to need a little more for this road. It wasn't permitted. It's not built to the appropriate hillside ordinance, et cetera.
Counsel, what do you mean? I can help with the road, and then a road appeared. So,
there used to be a gravel.
I know, but did she help with the road? What was her involvement with the road?
Well, her involvement with the road, which is that's why the facts are important. Her involvement with the road was not the road. Their involvement with the road was she helped arrange for the surveyor and the people that drew the road in and drew out the specs and provided the information to Katie West, because at the time she was thinking she was going to be listing homes that were going to be built.
Did she have a conversation at some point with Jonathan Stanzel?
She does not recall it, but for my purposes, it's not important.
But for our purposes, she did have it.
Well, I'm going to convince you that for your purposes, it's not important, I hope.
Okay.
But in the end, it goes on to we go back to the jury instruction. She has the conversation, and we can presume she was told it's a road, it needs to be permitted, it needs to be built, it's going to be complicated, going to take some time, whatever. She then brings the information to her principal. Her principal decides, apparently, I'm not building homes, I'm just going to sell the land, and puts the land up for sale, 4 different lots, hires her to list the 4 different lots, and in the meantime, without her involvement, the unrefuted testimony of the land, of the road builder builds a road, and you have the contract and evidence in which they never met, saw, nor knew, hide nor hair of Debbie Cox, puts in a road. Debbie Cox happens to live in the area. Says, wow, they're putting in the road. So what does she see? She sees a road put in. Big equipment, heavy equipment. Remember, the Helmke's own contractor who's going to build their house is impressed with this road and also never questions this road. I'm a real estate agent. I represent a real estate agent. The real estate agent doesn't know whether it's this way, that way, this way, that way, what it needs to be on the side, whether it meets the grades,
She's not
et cetera.
surprised in the least that she had been told by Mr. Stanzel that something like this would take at least a year just to get the permits from the
Why would a
Maricopa
real
County.
estate agent care about whether it would take a year or not? Or whether it would or it wouldn't? She sees a road being built. She's not a road builder. And I guarantee you, Your Honor, that you could go out tomorrow and hire enough people and have that road done in almost no time.
Once the permitting was finished.
The permit might even be conditional. The permit isn't going to necessarily take a year, and Stanzel's not the county. And incidentally, according to the record, there was a permit, but nobody could find it. But again, not important to this case, because what's important to this case is, what is she supposed to pass on? She gets told, and that's when now we get to, okay, I'm representing people, I'm going to help this thing. There's a road. Nobody has reason to question this road. Nobody. Nobody ever questioned the road until a year after the road was completed and they decided to build a house. Remember, this road itself was not even completed during the negotiation phase. The Helmke's negotiated a holdback and some work to be done to finish the road because everybody knew, well, probably going to put utilities up. Best way is going to be along that road. Let's not finish off this road. We'll do it later. That's exactly what happened. So the Helmke's know they're buying an unfinished road when they buy the property.
No, so just to be clear on one fact is she's now representing buyer and seller,
She's
correct?
in the trade, what's called a dual representation, and executes the dual representation document that's commonly used. Yes, she does represent both.
So what is the duty she owes to the buyer?
Everybody recognizes she has duties to disclose.
Of full and frank disclosure?
Full and frank disclosure, and she owes those duties, and she has to disclose what she knows. Both the experts say you got to disclose what you know.
Merely what she knows. So a realtor, is that a realtor only has to disclose what they know?
A realtor's job is not to investigate for the buyer or the seller. They do their own investigation. It's contained in the contract, and both of the experts testified that the due diligence obligation rests on the principals, not real estate agents. Again, unless there's reason.
She owed her client, though, a fiduciary obligation, correct?
Well, a fiduciary obligation is a nice word, but what does it mean?
Well, and I understand that that's what we're asked to
Right.
wrestle with.
And
but-
that's what this is part of.
Well, but there's fiduciary duty claim that went to the jury.
That's right.
And that's not true in the applicable portion of Aranki.
That's true. But then again, if you read what you want to call complete Aranki decision, there was a dual agency discussion. The dual agency discussion related to the fact that we are often dual agents, such as escrow companies that have to answer to both sides, and they have the same issues. And that's when the discussion and narrowness of whether we're passing along information unless we have reason to know the information's wrong.
Well, but
Okay.
and I want to ask you first, before we go there, about a question about Katie West, because you mentioned them. I will tell you they're a bit mystical to me from the record.
They're very
because,
mystical.
Well, for reasons that we may be meaning different things about. They were named as a party. I'm not sure where they are right now, but it looked to me like the trial court entered a judgment that at least is susceptible of being read under 54B. Do you agree?
Well, I think the judgment was entered under 54B because there's never a judgment against Katie West, and they were never
I
defaulted.
think we're saying the same thing.
Right.
I just, one of our obligations among many is to
Jurisdiction.
make sure we have jurisdiction. And look, do you agree we have jurisdiction over?
Absolutely agree. That's why I inserted the 54B language. And not pertinent to this appeal, there was a lot of go-around on the effect of the answering, non-appearing, but not defaulted plaintiffs, and I decided not to appeal on all those issues, but from a jurisdictional point of view, we're right where we're supposed to be.
Okay.
That's why there's 54B language. If you were to remand, I think we would remand, and we would still have Katie West floating out there.
But for the citation of the rule, I read the language exactly the same
Right,
way. And
very
I'll
good.
ask your counterpart as well, but one of the things I want to get is agreement where we can find it.
So now this road gets developed, and when this road gets developed, information is shared. The information from Katie West, who is absent, who And we start to use for the experts, we discuss the obligations of real estate agents. The court discusses, I'm going to talk about the law. These real estate agents, these real estate experts who recognize the standards from the law can't talk about it. Strikes testimony from my expert. We go on to the trial. I'm never allowed to make this argument. I'm never given this instruction. And to add insult to injury, plaintiff's counsel gets up at a number and says, well, we're talking about all these statements by Katie West who aren't here. They're not there because they don't put them there. Candidly, I don't put that burden on them.
Well,
I'll tell you why.
You
They
had
just
the
disappeared.
subpoena power too, I think.
I did have the subpoena power, and we both subpoenaed them for depositions. We both tried to get a hold of records, and they ducked us forever. There was one ambiguous deposition taken by one of the principals that neither one of us used because it was like, what the heck? But they never produced their file. We didn't get the contract for the road until we found out who the road people were because they basically ducked and provided no information whatsoever. We even discussed trying to compel them. At one point in time, we even found them in a different place, and by the time they were there, they were gone. Incidentally, one of the guys was a debt avoidance counselor. But that's bottom line is Katie West isn't there, and it is a big hole. It's a big hole for everyone, but from my perspective, the burden's on the plaintiff. And if the plaintiff decides to act like, oh, they're absent here, and I now get an instruction, I don't get an instruction that says we don't have responsibility for passing along information unless we believe it's bad, and all I have argued against me is, where's Katie West? What did they say? They're out-of-court statements. This is just Debbie Cox. This is just Debbie Cox. That's important instruction when I have a court. The court who told the jury when she struck my expert testimony that I will instruct you on the law. I don't get these laws, this statement read to a jury, which was, candidly, my entire defense. So is it fundamental? Yes. Is it reserved? Yes. Was it talked about ad nauseum yet? Did the plaintiffs take advantage of the absence of the language? Absolutely. I leave my time for whatever remains.
Thank you, counsel. Mr. Berry.
Thank you, Your Honors. Christopher Berry, Berry Law Group, on behalf of the Helm Keys, Richard Gilmore of my office is with me today for the honor of being here. Your Honors, let me go. I want to get back to this issue, which I believe to be the only issue on appeal, which is whether the court erred in not submitting requested instruction number 11. And as I read through the appellate brief, there were times I had a difficult time understanding all of the issues that were in play, but it seems to me that this is the crux of the appeal here.
Counsel, before you do that, and
Sure.
I want to hear from you on that point, we all do, but let me ask you about the 54B.
Right.
Do you agree the court properly has jurisdiction?
I do. I agree the language was appropriately included, and I agree that the court has jurisdiction. And if this court would like me to respond to any of these issues about Katie West, I would like to do so. I'd like to put that at the end of my argument, though.
Very well.
At this time, what I'd like to address is this issue of requested instruction 11 and the Aranki decision, which you've read a great deal about, and why requested instruction number 11 is simply not an accurate statement of the law for the purposes of this case. What we have is the instruction itself is actually misleading, if anything. Aranki very specifically was a single representation case in which the broker was representing one party to the transaction, and the action was brought by the adverse party to the transaction. This is not that case. This is a case in which, obviously, as the court is aware, this is a dual representation context in which the agent has specific duties that are higher than certainly the duties that would be owed by an adverse broker. And Aranki really doesn't say what this instruction says. I mean, Aranki essentially specifically says it's the seller's real estate broker at issue there in an action brought by the buyer. And the Supreme Court, when the Supreme Court looked at Aranki in Lombardo, basically said Aranki simply acknowledged the compatibility of the fiduciary agent, of fiduciary duties of an agent owed to the client when there is a duty to deal fairly with others. And so it sort of opened that line of reasoning. Prior to that time, there are questions as to, well, what if I have a fiduciary duty to one of your honors in a transaction, and I find out that there's some negative information or something that would be very material to the transaction, my fiduciary duty to you might prevent me from disclosing that under any circumstance. And Aranki said that that's not the case, and that's been verified by the Arizona Supreme Court in Lombardo. So on the first instance, Aranki really doesn't say what it's being held for. And in the second case, it would be misleading because this particular instruction appears to be, if you look at the context of the case and the overall instructions that the court has given, in this multi-claim complicated scenario, if you look at just Aranki, what it's being used for here is something like a ripcord. Like this is the only thing that a real estate professional can be found liable for. And therefore, if this instruction had been given to the jury, it would seem to be they might wrestle over this issue, disregard all other testimony and instruction regarding standard of care and regarding the duties owed as an agent and as a fiduciary, and go directly to this one thing and say, well, wait a minute, it's like a ripcord. If we don't find this, and we don't find that she had been told false information by the sellers and then turned over that false information to the buyers, that there can be no liability. And that's simply not the case. The experts in this case were able to opine as to the standard of care. Each side agreed on two propositions which I think govern this case. Those two propositions are that there is a duty of a real estate professional to investigate a situation when that situation is called to the real estate professional's attention. And in this case, the record is clear that the Helmkeys asked Ms. Cox on several occasions, what is the status of the road and is it a good road? Now, to accept Mr. Thomas's notion that, well, she didn't have a duty to know about the road, she had been told that it was a good road, and that's all that she had an obligation to do, that's false. Because the real estate professionals on both sides, including Mr. Martin, testified that when your client raises an issue, a duty of investigation certainly does arise. And in addition, the real estate professional, the experts also agreed, has an obligation to not speak recklessly about a subject on which the real estate professional is not educated. So if Ms. Cox simply didn't know what the status of the road was, then it was her duty to not say anything. So even if there's no duty of investigation, she certainly has a duty to not assure the Helmkeys that the road is in quite good shape and has been engineered, which is the quote that was used during trial, that she claimed that the road had been engineered, which implies a tremendous amount of work, and it implies permitting, and it implies that the road is a valid structure and can be used.
Counsel, let me ask,
Sure.
the claims in this case that were submitted to the jury were fiduciary duty and a form of negligent misrepresentation.
And professional negligence, Your Honor, also.
So three claims.
Yeah, three basic claims. That's essentially what we argued was. Yes, Your Honor.
Although that doesn't come screaming out from my reading of the jury instructions, frankly, and it was a general verdict.
Yes.
Does Aranki, the discussion that appears, the discussion that contains proposed 11, appears from my read to be in the negligent misrepresentation discussion for a claim by a stranger, not by a client. And the question I have really for both sides, and I ask it to appellant, is whether Aranki in any situation would have application to a fiduciary duty claim as opposed to a negligent misrepresentation claim.
I understand. In my estimation, Your Honor, I mean, the fiduciary duty claim obviously elevates, and it does have a higher level, perhaps, of proof necessary. So I think Aranki, I don't know why there wasn't a breach of fiduciary duty claim in Aranki, except that there was no privity or no specific relationship, whereas there is in this case.
Well, it's not clear to me that there would have been a fiduciary obligation by another party's agent to the stranger to that relationship.
So I think they can certainly coexist, but I think that really the Aranki situation if anything, exemplifies that when you go further and you've got a dual representation context, that there are additional duties and there are elevated duties. I mean, this was the Helmke's broker. I mean, this was the person who was representing them, and the evidence shows that she assured them that she could fairly do so. She told them that the only restriction on her duties to the Helmke's was that she couldn't give the Helmke's the seller's bottom line. But other than that, there were no restrictions on her capacity as a dual representing agent. Obviously, that scenario is missing from Aranki, which I think is why this entire appeal and the nature of this being argued as Aranki demands this is that cliche apples and oranges situation. I mean, we have an entirely different set of duties that are at work here. Another reason that Aranki really doesn't fit, if we go one step further, is that there's, quite frankly, more than sufficient evidence in this case to show that Ms. Cox did know that this road was not appropriately constructed. The record in this matter will show, Your Honors, that Ms. Cox structured this entire lot split. Ms. Cox did all of the legwork with respect to the lot split. She did the documentation for it. She went and engaged Mr. Stansel, although others paid. Katie West paid Mr. Stansel. She was the one that had the meetings with Mr. Stansel. She received the information from Mr. Stansel about what it was going to take to build this road and to construct the road, which in all candor, Your Honors, to an experienced real estate person who's doing raw desert lot splits, that you need a properly permitted road conforming to county standards is not a stretch. One is going to know that. And I think what we had in this case that Mr. Thomas has had a difficult time grasping is that the jury heard Ms. Cox say, I didn't know anything about the road. They just didn't believe her because it wasn't credible.
Where does that take us, though, on the legal question of whether requested 11 should have been given?
I understand. And actually, I'm not surprised you just asked that, Your Honor. But the instruction itself to go, you're saying, projecting forward, okay, fine, if she had that information. So she would have satisfied it if it was given, but it wasn't given. Is that essentially what you're conveying?
Effectively.
Yeah, that's what I thought. And I think that's a reasonable inquiry. But the issue itself and what I'm trying to address with what Ms. Cox had is going essentially to, what's been argued prior to my coming up here, which is that Ms. Cox was innocent, Ms. Cox didn't know anything, and that is essentially the way that it is, so that there has been some issue here with Ms. Cox being prejudiced because there's this given fact that she doesn't know or she didn't know the road. The fact is the evidence shows that she did know that the road was bad, that she constructed it, that she certainly either knew or didn't or had sufficient information to know. And the reason I think that plays out is because there has to be, if the failure to give the jury instruction here, even a failure to give a jury instruction is acceptable as long as it does not prejudice the other side. And a component of this has got to be, a component of this appeal and a showing by the appellant is that they have to have been prejudiced in some way. Just getting to the structural rules about, or the structural standards about what the judge is facing, during this critical time in trial when a lot of stuff is coming in and the judge is doing the best that the judge can to compress the law, make it work with these facts, and come up with cogent jury instructions. Perfection is not required. And in this case, Judge Duncan gave very thorough thought to this. She issued a very well-crafted professional negligence Raji-based instruction that was really like the MedMal one or like the Raji instruction for other licensed professionals, because as the court's aware, there's no Raji yet for real estate professionals. And so she did a good job crafting it, and by not giving this additional instruction that was requested, there was no prejudice. And I think that's the crux of why I would present this evidence to the court and point out to the court that it is not a case where it's a given that Ms. Cox didn't know about the road. She testified to the jury as to everything she was told. She testified that she was misled about the nature of the road. I didn't ask these questions, Your Honors. I wasn't there arguing that Katie West had told her X, Y, or Z. We argued at trial and presented at trial all of the information that Ms. Cox knew about the road and the information really that Ms. Cox should have known based upon, what she had. So there is no prejudice to it. The jury didn't buy it. They didn't believe her. And the fact of not giving this instruction as requested did not cause her any prejudice. Your Honors, with that, unless you have any further questions, I'll...
Thank you, Counsel.
Okay. Thank you.
Mr. Thomas, rebuttal.
Thank you. I concede there's sufficient evidence and did not appeal on the lack of sufficient evidence for a jury to find what they found on the instructions as given. Now, the idea that Ranke stands alone as a case in which it must only be against somebody who's not their agent doesn't work because of the citation to Berkins in particular. Because Berkins talks about the obligations that arise out of discovering certain things when you're the dual agent, which is what the escrow company is. So if you want to isolate a Ranke like that, then you did a disservice or the prior panel did a disservice in writing the case the way they did. Because that case had essentially dual agency involved by analysis. It was against the seller's broker and the buyer's broker, but it wasn't sufficiently pled against the others or briefed against the others. And in this case, there is disclosure on the dual agency. There's a signed document, and there is this higher duty. I don't know what higher duty means. And we had the case on fiduciary duty and legal fees. I can't remember the name off the top of my head, talking about we just give a basic instruction, and we give the instructions that are necessary. The instructions that are necessary here, and this goes to fault, and fault apportionment includes the instruction that's not given. Because you see, when the plaintiff gets up and argues about, oh, where's Katie West, and you don't know whether Katie West said this is all Debbie Cox. It's all Debbie Cox. Who's here to say anything about Debbie Cox, right? Well, guess what? If they knew that passing on information from the seller is okay, and they got information passed, and they were told by the court information by passing on the seller is okay, well, maybe the fault share is now 30-70, not 70-30. That's one of the ways that there's legal prejudice. I mean, there's clearly prejudice under the cases I cited you under simple jury instruction law. If the theory of the case is supported, the judge must give the instruction. It is an abuse of discretion to not do so. So this idea of, well, because the jury could have found what it did under the way it was done, I wholeheartedly agree with, but it wasn't done correctly. There is that single uniform jury instruction. We have RAGIs for other areas and professionals. We don't have any for real estate professionals. But with a real estate professional, this is the essence of what they do. Whether I represent both sides of the transaction, which is very common, and a form that's created, which the experts testified, and they didn't say there was anything particularly different, either of the experts. They said you have to disclose what you know.
But let me ask you, with the fiduciary duty claim, and I struggle with that some, because it doesn't seem to me that Aranki, the language that proposed 11 comes from, wasn't from a fiduciary duty claim. And those two standards seem different just by using sort of fiduciary and negligence in the broad sense.
If you stand up to a jury and say you have a duty of due care, and then you say you have fiduciary duty, that doesn't explain anything.
Fair. But if you explain to the jury in instructions what a fiduciary duty claim means,
that's right.
Which did happen here.
It says you owe a duty of care. You owe a duty of disclosure.
Could the instruction have been more robust? Of course, but that's true in any instruction.
More robust, and maybe that's a way we're talking about this. The reason this is a lacking case is because the instructions were not robust enough.
But let me ask, and again, we're looking at a narrow sliver, and the parties have done a delightful job of helping us focus to a single important issue. Should this instruction have been given? Was it required to be given? And I struggle with where even Aranki says that text applies to a fiduciary duty claim as opposed to a negligence?
It doesn't say it applies to either. It sets out the components. The fiduciary duty allegation, I think, was made against the other broker, but there was no evidence and it was kicked out, and they really talked about the exculpatory language. They also talked about the claims of representations, and let's fast forward a couple of years now to Lombardo, which discusses Aranki. Remember, Lombardo talks about how the regulation, which talks about a fiduciary duty and dealing fairly, and then gives specific examples, embodies the standard of care by the duty owed by real estate professionals. And that was another case in which we have that scenario involved. But in this scenario, when you understand the standard is testified to by both experts, agree to, is you must disclose material information you know. And you know where that standard comes from? Not from experts, by reading the administrative regulation that says so. So that's the minimum standard that's required by our professional licensors. And that's what this is about. Did you disclose what you knew? This is, by putting this label, fiduciary duty or negligent misrep or professional negligence, we're not talking about the heart. The heart of this case is, did Debbie Cox disclose what she knew that was material to the transaction? And did she have to disclose a conversation under a different agency relationship at a different time, a couple years earlier, about her conversations with a man who did the plot maps? Fast forward it. Now, does the jury care about that? I don't know, because I got cut off at the knees, because I get to say, hey, we saw a professional build. Max Christensen saw the results of a professional build. We were told it was a professional build. The exact testimony was Mr. Delgado, K.D., Mr. D, said this was an engineered road. And this road was built. And by the way, it's not done. There's more to be done. It's not like this road was ignored and there were a couple of statements. It's not like this road didn't exist. And by the way, the road really isn't even on the plaintiff's property. They don't own the road. This is an access road across someone else's property. I don't think that's I thought about what that might be a distinction without a difference, because you have to make disclosures about material to the property. That's not the property; it's neighboring.
Pretty material,
but
isn't it?
I think getting there's important.
That seems important.
I think getting there's important. But and those are the nuances that we are wrestling with. But that's not a nuance when I ask a court to say, tell them their responsibilities for passing information. And let me tell you why this is important, and why you can't duck this by saying, oh, fiduciary duty, which is in every case, the label fiduciary duty. Fiduciary duty incorporates, in many respects, due care. More importantly, it incorporates disclosing what you know. That's what they always talk about in fiduciary duty. That's the same thing to me, fiduciary and disclosure.
I'm not sure
treats it that if you have a duty of due care and you have a duty of disclosure, that pretty well sums up what a real estate agent can do. The idea that somebody says, hey, what do you think about this road, that they're going to run around and talk to experts about whether the road's good or bad, that's not, and neither did the experts testify that's their obligation. But what we are at, and I'm going to go back to where I went, words mean things, and this is the heart of the real estate industry. You can't let real estate agents or any agent who is in the process of repeating information, providing information from one side to another, even if she didn't represent them and they said, as a sole agent, the home said, what do you know about this road? Let me know. I'll go find out. And I went and talked to Delgado and told Delgado the exact same things that Delgado said, we'd still be standing here. It's not the label fiduciary relationship. It's the information. And if you cut off the agents at the heart, right at the knees, and say, don't say anything because you might be liable, because that's the result of this instruction not being given. Thank you.
Thank you. Counsel, we appreciate your briefs. We appreciate your oral argument today. We will take the matter under advisement. We'll issue a written decision in due course. Thank you. We stand adjourned.
Thank you.